HB 2365 is drafted to enable the most unscrupulous site developers to build cell towers on people's front lawns. That's how bad this law is. If you don't get this thing amended or repealed, you're going to be totally stripped of the power to protect your constituents, and it's going to be bad. So I'll give you some of the easy things to point out. So the first deception contained in this law is use of the word co-locate. I'm going to tell you why it's in here. The only reason the words co-locate and co-location are contained in HB 2365 are to deceive readers. That's the only reason it's here. When you look at 2365, they add the word co-location and define it to mean install, mount, maintain, modify, operate, or replace wireless facilities on or adjacent to a wireless support structure. It doesn't say add it to an existing pole. It does not limit it to an existing pole. In fact, what it says is they can put it anywhere on anything as long as it's strong enough to hold the antenna. Now, what about right of way? What is a right of way? Do you think it's only main roads? The definition of right of way in this law includes roads, streets, sidewalks, alleys, and utility easements. If you have electric power run to your house, there is a public utility easement on your private property. Site developers use this to put cell towers on people's front lawns. So when it says, oh, only in rights of way, that's intended to be deceiving, basically. It's to mislead a reader to believe they're only thinking about putting it in main roads or on main roads. Nothing could be further from the truth. So at the end of the day, site developers can use this code, this state law, to put an 80-foot cell tower on someone's front lawn. One of the other constraints the Telecommunications Act imposes, it says local governments cannot effectively prohibit the provision of personal wireless services. Get this, the state is prohibiting local governments for asking for evidence without which federal law prohibits you from turning down any application for any wireless facility. Why would the state do that? What does that mean? Well, here's what it means according to federal judges. An applicant can come in and force you to allow them to build a wireless facility if they can prove two things. Number one, they have a significant gap in their personal wireless services, and the installation they want to build in the place they want to put it at the height they want to build it is the least intrusive means of remedying that gap in service, and there's no possible less intrusive alternative locations. Now, applicants claim this every single time they file an application. And sophisticated local governments say, okay, you have a significant gap in service, show me your data. And if they show them the data, the board that's deciding the application, whether it's a planning board or a ZBA, gets to make a factual determination of whether or not they have a significant gap. Again, they have to base upon substantial evidence. This state law prohibits the local government from asking for them for that evidence. And without that evidence, federal law says they can't deny the application. That's how insidious this is. And ask yourself, why would a state ever do that? Why would they strip a local government of simply the ability to ask for evidence to support the application? That's why this is, I can only describe as insidious. And then finally, this has what I call the bulk filing rule, which is another insidious provision. It basically says that an applicant can file one application for an unlimited number of facilities. And the local government then has to make a decision within 60 days. If they don't, it's deemed approved. They don't have to go to court. They don't have to do anything. That means that they can file one application for 100 facilities, 20 cell towers, 40 small cells, and 50 DOS nodes. And the local government has 60 days to process those applications, or they're automatically all deemed approved. Again, why would a state do something like this? So unfortunately for Pima County, you are faced with one of the worst, shouldn't say one, two of the worst state laws you can possibly have, because when you add to this SB 1487, which says, by the way, if you violate our state law, we cut off your state funding. It's a horror show. So the best thing that Pima County can do is make its 980,000 citizens aware of the fact that the state has a completely insidious state law. And as a result, they should expect that at some point in time, they're going to start waking up to see wireless facilities on their front lawns. If you don't get this thing amended or repealed, you're going to be totally stripped of the power to protect your constituents, and it's going to be bad.
What would be our recourse for sites in the right-of-way that are subject to 2365? I think that's where my question would be.
I would start filing complaints with the FCC. I would bombard them with complaints if I had to. And it's easy. They're free. You just file them. I would also make the homeowner aware that they can file complaints with the FCC, because you have to raise awareness. Well, what's supposed to happen is you're supposed to be able to file a complaint with the FCC, and the FCC is supposed to do something about it. Good luck with that. I have seen cases where people have tested facilities and found the facility exceeding the general population exposure limits greatly, 5 times the limits. And they call the FCC with a complaint, and they complain 5 times on 5 different occasions. And the FCC maybe comes down and gives them a warning, and then a second warning, and a third warning. The only time I've ever seen the FCC actually do anything is after they had to go back 5 times for the 5 facility. So I think they've issued something like a dozen violations for 1 million facilities in the past 28 years. So if you think the FCC is going to do anything to help you, you're mistaken. It's never, ever going to happen.